I'm the Project Technology Manager over at CJCA, and I'd like to welcome you all to today's webinar. This webinar is the second in a series produced jointly with CJCA and the Center for Educational Excellence in Alternative Settings, or CEEAS. We want to offer some practical advice on the guidance package that was released jointly by the U.S. Departments of Justice and Education. And your participation in the first webinar, which is already passed, it was not a prerequisite for today's discussion. That focused on the 5 guiding principles for providing high-quality education in juvenile secure settings. And like I said, if you missed it, we'll provide you with a link. I highly recommend viewing that presentation as well. But today's presentation, we're going to focus on the department's Dear Colleague letters. Before I hand things over to today's moderator, I'm just going to do some quick housekeeping and run you through some features on today's webinar control panel. You have the option to listen to today's presentation either on the telephone or using your computer speakers. Just make sure that you've got the right option chosen on your webinar control panel right on your screen. If you're calling in using the telephone, make sure you've chosen that Use Telephone option. We find that those that have problem with feedback or some unwanted echo, this really helps reduce that and hopefully will improve the overall experience here with today's audio. If you want to ask questions to any one of our panelists, you can type those questions in also on this control panel. It's towards the bottom. We'll be taking time for questions at the end of the presentation, but please feel free to type them in at any point. You don't have to hold those questions for the end. Type them here. We'll try and address as many questions as we can by the end of the webinar. And of course, as always, today's webinar will be recorded and archived for future viewing. We'll be sure to provide the slides, any other resources that are mentioned during today's presentation to you in follow-up emails. Emails with the link to the presentation will be sent out by next week, so if you haven't received them right away, just look out for them in your inbox next week. We'll mention a handful of things throughout the presentation here today, and we'll make sure that we follow up with all of it. I think I've got everything covered to get us started, and I want to get us right into today's presentation. So I want to hand things over to today's moderator. It's the Director of Special Projects at CEEAS, Haley Corman. Haley began her career in education with nearly a decade in the classroom, working primarily in high-need public schools in Los Angeles. She went on to earn her JD from UCLA School of Law, and prior to joining the center, Haley was an attorney at Morrison & Foerster in Los Angeles. At the center, Haley oversees the development and implementation of many of their national projects and also directs much of the legal and policy research with a focus on improving outcomes by protecting the education rights of students in custody. So Haley, thanks for leading the discussion here today.
Thank you very much, Brendan. All right, so I'm looking forward to talking with you all today about the 3 Dear Colleague letters that were part of the guidance package that you all have seen either when it came out in December or you've seen recently. Excuse me for a minute. There are 3 letters that came out, one focusing on Pell Grants, one focusing on IDEA, and one focusing on other federal civil rights of students. We're going to walk through them in that order. On today's webinar, we've got me. You'll be hearing from me. You'll also be hearing in order of appearance from Frank Martin. Frank Martin is the Education Administrator for the Oregon Youth Authority. From Kevin Burnett. Kevin is the Site Superintendent in Lewiston, the Idaho Department of Juvenile Corrections. We also have with us 2 folks from the U.S. Department of Education. We have Saba Bireda, who's Senior Counsel, the Office for Civil Rights in the U.S. Department of Education, and Kristen Harper, who's Special Assistant to the Assistant Secretary, the Office for Special Education and Rehabilitative Services, the U.S. Department of Education. I want to think through some of the expectations for today's webinar. The folks from the DOE today are here to help clarify the documents that you've received. And the purpose of the webinar is to help you think through the guidance package and begin to think through its implications for your program. We want to make clear, first of all, that this is not legal advice for any site or issue. All of the polling responses that you're going to be asked to participate in today are anonymous, and they're simply information for us to guide our discussions. CEEAS, myself, my colleagues, we're here to help provide you support for implementation and give you some ideas for best practices. That's also why we've got Frank and Kevin on the line. And at the very end, you'll see some contact information for all of us today. We've decided to focus on the portions of the package that we believe are causing the most concern or may require substantial changes in current policies or practices. So we might not touch on everything that's in that package. If you have a specific question that we don't address today, again, you'll get contact information to reach out to any of us at the end. So again, we'll start with Pell Grants. We'll walk through the Pell Grant letter, think about how you can make that work for your students. The IDEA letter, focusing on child find, discipline, shared responsibility among agencies, and least restrictive environment. And then we'll move into the federal civil rights protections, focusing on English language learners, FAPE, and solitary confinement. So the first thing I want to do before we get started is to talk about the polling questions. As we move through this webinar today, we're going to be asking you some questions about what's going on in your sites, what's going on in your programs, what's going on in your classrooms. There are going to be 5 answer choices for every polling question. The answer choices won't change, and you may select all of the choices that apply. And again, please remember that these are entirely anonymous. So you may think that you're not able to do something because you don't have the right resources or staff, because another agency has control over it. You simply didn't know about it. It is your policy, but you're having trouble implementing it, or you simply don't understand how to make it work. So our first topic today is the Pell Grants letter. Students in juvenile justice facilities are eligible for Pell Grants. Now that you know that, how do you make it work? So if we read the letter is very clear that all students who are confined in what's defined as a juvenile justice facility are eligible for Pell Grants, and that's regardless of the court system or statute controlling their confinement. The definition of a juvenile justice facility is given right there in that letter for you, and we just want to emphasize on this point that this includes students who are serving what are sometimes known as blended sentences or who are held under a dual jurisdiction statute. This even includes students held in a juvenile justice facility who are being held under adult conviction. Sorry, folks, I have a little bit of a delay on my... There we go. So how do you take advantage of Pell Grant eligibility? What do you do for your kids? We've got 4 steps that Frank's going to come and talk with us about in just a second. The first one is that you prepare or solicit a legal memorandum. What does that mean? So what this is a letter that comes from either your agency director or your general counsel or even your state attorney general, clarifying that your facilities are in fact juvenile justice facilities under the definition of the Dear Colleague letter. You meet the requirements of that letter. Second is that you would prepare a packet for your students. That packet would include that state or agency legal memo. It would include the Dear Colleague letter, the Q&A for college financial aid offices, and the fact sheet for incarcerated students. If you can prepare that packet and have that ready for every kid, you put them a step ahead when they go to approach university. The third thing you can do, however, is you can also make that first step to build that relationship. So you can begin by approaching nearby community colleges and universities to establish partnerships. And the final suggestion we have is that you try a pilot program with a small number of students. This allows you to provide them the resources and support. It allows you to do some tutoring and mentoring to support students, to offer peer support, to offer study hall and tutoring time, to help students select the appropriate course load and coursework for them. It also often requires online access. So what I'm going to do is I'm going to hand it over next to Frank Martin. And Frank Martin's going to talk about what they've been doing in Oregon to make Pell Grants accessible for their students. This is something they've been working at for a long time, but they've also made some changes as they've received the letter and they've gotten new information. So Frank, I'll hand it over to you.
Thank you very much, Haley. And that was a good outline. Matter of fact, probably every step is something that we had taken to get the verification for our older youth. The reason why Oregon has quite a bit of experience with the Pell Grant is that we do have older youth in our facilities. In Oregon, we have youth that range from the ages of 12 all the way to 25. And so we have infrastructure already built in to the agency to work with young people in higher education. So we sent the material, the Dear Colleague letter, to our Attorney General, and that's the pathway that we had taken. And we had verification from the AG, and then we shared that information with our principals, but we also extended all that information to our community colleges and universities that we work with, and that was very beneficial because they also received information from the U.S. Department of Education about the new definitions with the Pell Grant. And we were able to sit around a table and talk about how we thought would be the best practice for approaching this, because it is a larger number of young people that will now have access. So we are fortunate. All of our facilities have internet access, and we have a Oregon revised statute, an OAR, that puts it into law that allows young people to have access to the internet for education. We drafted that with our peers in education and floated it for public response also. The best thing is to have that infrastructure set, that everybody knows their roles and responsibilities, and that means from your line staff to the teachers. So we have access, but we also have regular learning with other courses in education with visiting professors. That's another option that you may choose to have. We cooperate with our folks at the community college, and this is very important because there are limits to the amount of money for Pell Grants. So we emphasize to our young people to try to focus on community college. And the reason why is that they have more bang for the buck, to put it honestly. And we emphasize that the attainment, that is, of trying to get an associate's degree while they're with the Oregon Youth Authority. One of the greatest challenges that you'll probably face is when you do have the grant, what do you do with the money? And we're always looking at improvement with that. We met with our business administrators and also with the community college, and we look at the youth trust accounts, and we look at policies and procedures to develop the use of those fundings, and also making sure that we do it in a timely, efficient way. So one avenue that we have is trust accounts. We're even looking at expanding a sort of a recommended procedure with the community college, and we're exploring this right now to see if the community colleges can handle all of the money regarding the Pell Grant with the youth, and that would take us out of the picture. And we had learned from some directors that in the past that's how they worked with the Pell Grant when it used to be back in the Clinton administration, how they handled it. So we're investigating that right now. We're always looking at improvement and streamlining the process. It's a great opportunity for young people. You have to let them know that this is for the course, and this is only for the course and the books itself. And so that needs to be articulated. It doesn't mean buying a bunch of other things that other youth in the community may be doing. The objective for the Pell Grant is on paying for tuition and books. I cannot overemphasize communication with your programs, that is your partners in the community colleges, and also with the people that handle financial aid. Building those relationships is very important for this success, and sharing information with your administration and with your school staff. So it's quite a challenge. We literally have our facilities with 8 different school districts, so we have to make sure that we communicate to all of them. But the best thing is to have coordinated policy that gives you that straight line when you roll out the program, and good communication with your staff that are implementing the program with the young people. I know I threw a lot out there, but I try to give you a breadth of it all.
Thank you, Frank. And we will hopefully have some time for questions at the end. We're also going to give you all Frank's email address so you can bombard him with all of your questions.
And Haley, could I, there's one item I forgot to mention, and that
Absolutely.
is email access. We have a policy on email, and the youth know that email is only used for education. and we have filters that we utilize for scanning the email. And we're also looking at system-wide of going with Google Gmail, because there's a little bit more security with that enterprise. I'm not promoting any products. I'm just saying what we're using. But email is something you have to keep on top of and make sure all the filters and the youth understand the policies when they sign off on their ownership. Thanks.
Yeah, thank you, Frank, and that's a great point. I think we all understand the security concerns with having open internet access and with giving kids access to email, but we also understand the reality that making online college courses available to kids is going to require them to have internet access and email access. And so finding the right balance there and really adjusting our threshold for risk for making sure that this is something that kids have access to. We're going to transition over into the next letter. I know folks already have some questions about the Pell Grants that we'll raise at the end. We're going to talk about IDEA. We've got our folks from DOE here to help clarify the points in the guidance package that folks might be a little bit confused about, have some questions about, not sure they fully understand. What I just want to add is that what they're going to be doing is clarifying, again, the letters in the guidance package. Best practices typically go beyond the minimum legal requirements. You don't need to hear that from me. You all know that. But we also recognize that the minimum legal requirements are a necessary starting place. It is essential for us all to understand what that guidance package says, and we'll go from there. At the end of this conversation, we're going to hear from Kevin Burnett from Lewiston, who's going to talk about the practices that they've put into place at his site, and you can see how it plays out in action. So I'll turn this over to our friends from the DOE.
Thank you so much, Haley. This is Kristen Harper with the Office of Special Education and Rehabilitative Services. And when we issued this Dear Colleague letter on IDEA, we wanted to make one thing, perfectly clear. There's an overarching statement that we really wanted to clarify, and that's that absent a specific exception, all of IDEA's protections apply to students with disabilities in correctional facilities, and they apply to their parents. So that's just one, overarching concept that we really wanted to make clear with this letter, and that we hope you'll keep in mind. So with that, I'm going to go ahead and just give a few of the highlights from the letter. I'm not going to go through the entire thing, but just a few of the highlights, starting with the idea of shared agency responsibility. So, of course, states have different structures for how they provide education to youth in facilities. For purposes of IDEA, the state, as our grantee, is ultimately responsible for designating who within the state is responsible for the provision of a free, appropriate public education to students with disabilities, including those in correctional facilities. Now, the state, of course, has flexibility. It can assign such responsibility to an education agency, like the State Education Agency or SEA, but it can also assign responsibility to a non-educational public agency, like a justice agency. Now, whenever a responsibility is assigned to a non-educational agency, IDEA expressly requires that there be an interagency agreement in place to clarify how agencies will coordinate with one another, how they'll coordinate with the state education agency, and clarifying how will services be provided, how will the funding behind those services be provided for. Now, IDEA does not specify the form that interagency agreement must take. It could be a memorandum of understanding. It could be laid out in a statutory provision. But one way or another, that interagency agreement must be in place. Next slide, Haley.
Sorry, there's a little bit of a delay.
No worries. So as the slides transition, I just want to illustrate a little bit, how this can play out. Just this past year, there was a lawsuit that occurred against Contra Costa County and Contra Costa School System out in California. It was a case where you had 3 students with disabilities that had been placed in restricted settings for an extended period of time, without being provided education services. And it was a clear for the students' education rested with the county, and the county said responsibility for education rested with the school system. And in this case, there was very clear indication that, as is required under IDA, California's regulations clarify, who needs how the agencies need to work amongst each other to make certain that education services are provided to students in facilities. And we clarified through a statement of interest that together the U.S. Departments of Education and the U.S. Departments of Justice issued when this case arose, that both agencies were ultimately responsible under IDEA. And so the top line statement here is sort of laid out here that IDEA really applies to all political subdivisions involved in the education of students with disabilities, including those in facilities. So just a clear sort of illustrative case that's helpful to refer back to. Next slide. So another concept I just want to highlight for you is the idea of child find. And child find is just simply, it's the duty to identify students that are in need of special education and related services when they're in facilities. Even if a student, doesn't come in with an individual education plan under IDEA, that doesn't mean that they're not a student with a disability. That doesn't necessarily mean that they're not in need of special education services. So agencies, facilities really need to be proactive and always being on the lookout. For students that may be showing, signs that they are in need of such services. And it's important to remember here that, once evaluation is begun, that facilities have an obligation to move forward with a student's evaluation, even if the child won't be there long enough for the evaluation to be completed. So just an important piece to note about a facility and local agencies' responsibilities with respect to child find. Next. So another important highlight is the importance of providing a free, appropriate public education in the least restrictive environment. Again, unless there's a specific exception under IDEA, and there are a few, all the IEP, individual education plan, content requirements that apply to students with disabilities in correctional facilities, including the students' levels of academic achievement and functional performance, measurable goals for the student, the specific aids and services that will be provided to them to make certain that they can make progress in the general education curriculum, that is the same curriculum as for non-disabled students. It's also important to note here that when a student with an IEP transfers, the new agency, often the Justice Agency, must provide the student with services that are comparable to their old IEP until either that IEP is adopted or until a new IEP is created for that student. Also important to note that instances when a student would be provided special classes or separate schooling within a facility really should only happen in pretty severe cases. Only cases where the use of aids and services can't, when education in regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. So for the most part, students really should be in the same classes as other students with access to the general education curriculum. The last piece I'll speak about is due process and discipline. We clarify that students in facilities when placed in restrictive settings are still entitled to their due process protections. And, for example, any removal from the student's current placement for more than 10 days is considered a change in placement under IDEA, which requires a manifestation determination under IDEA. Let's go to the next slide because I think it'd be helpful to sort of illustrate, what IDEA means in the context for students placed in restricted settings. So I want to turn back to Contra Costa for just a second. Remember, this was a case we had 3 students placed in restricted settings without access to services. And in our statement of interest, we clarified that public agencies are not relieved from providing services to youth with disabilities based on disciplinary reasons. Direct threat or dangerousness is not a defense to the IDEA obligation to provide educational services to all eligible youth. So again, really, really important to make certain that your youth in facilities with disabilities, when placed in restricted settings, continue to have access to education services. So it's a very high level overview of our letter on the implications of IDEA, and absolutely looking forward to the coming polling questions.
So what we've got next are a series of polling questions that are going to start to get some of your responses to what you've heard, some questions about what's happening in your facilities. The first one is, do you have a written agreement with your State Office of Education assigning responsibilities to provide services under IDEA? You can choose any of the following that apply. We'll take a second, and then we'll have about 2 or 3 minutes for Kristen to respond to what you all are seeing out in the field.
Oh, wow, this is really interesting. So it looks as if about 39% of you said that another agency has control over whether or not there is a written agreement in place. Now, ultimately, the state is responsible for making certain that a written agreement is in place, and that that agreement, outlines not just how agencies will work with one another, whatever agencies have been designated to be involved, but how they'll coordinate with the state education agency, which ultimately does have responsibility for monitoring. So, perhaps a great place to start is to reach out to the state education agency just to figure out where this written agreement may reside. Again, it's not necessarily a single document. It's not necessarily a memorandum of understanding. It may be laid out in statute. IDEA, is pretty open about, exactly how, this interagency agreement is laid out. But it seems like a good place to start would be to go to the state education agency because, at a minimum, sort of that coordination does have to be in place.
Thanks, Kristen. We'll jump to our next question. And our next question, I know I've looked at the list of registrants, and we've actually got a lot of site-based practitioners. We have teachers, we have school counselors, we've got site-based custodial staff on the line. So your answers are totally anonymous. Just to remind you here as we move to our next question, are students with disabilities provided all of the support in their IEP or Section 504 plans, including aids for communication for kids who might need them? And folks, you can just click your answer right on the screen, and it'll log your choices for you.
So it looks like the vast majority of you said this is our policy, but implementation is a challenge. And I'll take a moment to speak to that particular issue, especially since we know that the issue of information sharing between education agencies and juvenile justice agencies can sometimes be quite a challenge. IDEA does require that agencies take reasonable steps to make certain that when students with disabilities already identified transfer, between agencies that the IEP is also transferred in a timely manner. However, there are also, that such sharing is also governed by the Family Education Rights and Privacy Act, FERPA. And we have some resources, to help agencies understand number one, understanding, yes, you are required to take reasonable steps to make certain that the IEP is transferred. And we also have resources to explain the circumstances under which such sharing can be done in compliance with FERPA. But this is definitely an area where we continue to hear that folks are confused about how to share the resources and information that agencies need to be able to provide students with the best services, but to do so in a manner that's in compliance with federal laws. So it's definitely an issue that we're continuing to think about. But we do have resources available to assist with that.
And as we move forward, I want you all to just keep in mind that at the end there'll be some contact information where you can reach out if you do have a specific question relating to implementation at your site or within your system where you would like some individualized support. Okay, so we're going to move into our next polling question. And this is, again, reminder, totally anonymous. Just click right on your screen. If students are placed in segregated settings in your building that you work in or in the facility that you manage or in the system that you manage, do they receive an education program that's commensurate with a full instructional day? You can click right on the screen, as many as apply to you.
And for this one, as once folks are finished answering, I'm going to invite my colleague, Saba Beretta from our Office for Civil Rights, to also weigh in on the response to this one. So again, it looks like folks, the vast majority of folks saying that this is, their policy, but implementation is a challenge. One thing to think about is, what types of academic and behavioral supports are available to students, placed in, in segregated settings. And to be honest, what kind of services and supports are providing students, prior to their placement in segregated settings. And in all honesty, the best situation is to, identify, effective practices that support students enough such that placement in segregated settings is less necessary to begin with. After that point, definitely want to make sure that coordination between juvenile justice and education agencies are in place to make sure that the students are getting the services that they need. Saba, do you have any additional thoughts on this?
I'll speak more to it a little bit later, but just referring, of course, back to Contra Costa and OCR's work around Title II. If students are in segregated settings due to a disability, then we would want you all to be aware of the Section 504 protections if they qualify for Section 504, protections that would ensure that they still receive FAPE even though they're in a segregated setting. But I can get into more of that during my part of the presentation.
Yeah, our next presenter, I'm going to head it over to Kevin Burnett, is from Lewiston, Idaho. Now, Idaho is one example where sites are putting this guidance, quite frankly, along with some good judgment and thoughtful care, into action. Their policies really go beyond the minimum legal requirements, but I think hearing from Kevin, you'll get a good sense about what good practices look like and how you can maybe think about making this work in your space. So Kevin, I'll hand it over to you.
Okay, thank you very much, Haley. I appreciate this opportunity, and I truly hope that I hit the topics and the things that are going to be helpful. I'll break it down in the briefest manner I can, yet still make some sense into 4 areas: the kind of current circumstances of our daily service delivery, what we're trying to do proactively, what some of the reactive approaches are, and then what our toughest remaining singular challenge is to making sure all educational services are provided in the manner that they need to be. First of all, we're a 36-bed facility. We do not take females or sex offenders, so that leaves us with a demographic typically of juvenile males ages 13 to 18. And in that group is, of course, the gamut of educational needs. They're on different grade levels in different areas in the same class. And we have to integrate them all into the 3 classrooms that we have. We have 3 units of 12 juveniles. Our teachers here are not from the district. They are actually hired as generally funded positions through the agency. And so they function not only as educational staff, but they also need to switch hats on occasion and use that group process or direct care staff role as well. That provides some significant challenges, as you might expect. Part of the things that we try to do to make sure we have all of the juveniles in that educational setting every day, all day, to the extent possible, with the mantra that we keep them in the class or get them back as soon as possible. Some of them are typical. I won't go over them. I'm sure they're found in every other setting like ours. Some of the other times that the other approaches that we have a mental health track here, and we have a transect of 3 different things that come together that we have found to be very significant. When we have a juvenile with high mental health, high conduct disorder, they typically or quite often have also high needs and education with an IEP and whatnot. Ironically, those are also the ones that have the highest level of acting out behaviors and quite often to an assaultive or physical extent. So keeping them in the classroom can certainly be a challenge in providing them with the services required. So some of the things that we've created here are we have a mental health track where one of our clinicians is designated specifically to making sure that this occurs, that their needs are met prior to the issues that might arise. They address any kind of diagnosis they might have. They talk with our educational staff about the implications of what that could mean in the classroom. Then they educate the teachers and the other staff throughout the evenings of what accommodations may need to be made for what that juvenile is presenting and some of his challenges that may not be seen in the rest of his peers. A couple of the other things that we do by way of proactive is we give the juveniles individualized learning strategies or self-time where something that we believe with their learning style or deficits can most effectively help them. That's, of course, difficult to do, especially if you have several that need that, but to the extent possible, we apply that. And the last thing that I would talk about in that second category of proactive, and as I'm sure some of you will be aware, there's two schools of thought on this, but one of the things that we have done is implemented 4, some people would call them social work approaches, but we've done some studies on light filters for fluorescent lighting that enhance focus and decrease the anxiety sometimes of fluorescent lighting. We provide a fleece in the pocket. It's a 2-by-2-inch piece of fleece in the pocket with something motivational printed on it or sewn into it. We have a morning meditation, and we also have a morning energizer. Some staff and some juveniles swear by this and say it has made all the difference. Others say it's touchy-feely, I don't like it. Nevertheless, we continue to do it because it seems to reach and be really effective for about 50% of them, and it certainly doesn't hurt those that it doesn't appear to be effective for. But with those approaches, you still have those opportunities where a juvenile does lose control, require physical intervention. And with that situation, we have the occasional need to look at separation, room confinement. And when that occurs, what we provided by way of our approach to that is we have a 4-phase ticket, so to speak, that helps staff quickly and effectively get them back into the learning environment. The first one is we observe that control is regained by the juvenile. Obviously, if he's pacing back and forth, clenching his fist, pounding on the wall, that's not observed control. So he needs to appear to be calm. We ask them if there's a retraction of threats. If he went in there and said, I swear the next time I get a chance I'm going to rip your head off, we ask him, do you mean that? Do you still have that intention? If he revokes those threats, that's number 2. The number 3 thing is we say, can you commit or contract for future safety? And we ask them to provide ways for us that he will problem solve or handle those situations differently than he did with the assaultive or aggressive behavior. If he does that, then we might provide just a really short group process-based learning activity. For instance, when we go back to the classroom, we'd like you to gather your class up, and we're going to talk for a minute about the impact that your behavior had on the classroom and let them kind of talk to you about what they need to feel safe. If he's willing to do that, he is back into the classroom, and that can be 10 minutes or 25 or 2 hours, depending on his readiness and willingness. If they delay and say, I'm just not quite ready, we have educational resources brought to them in that isolated setting. We don't have that very often because usually the turnaround is really quick. But I would just end in sensitivity to the time on our toughest remaining challenge, and that is that juvenile who has an IEP and needs significant educational offerings is in his room but says, I promise you, if you open that door, I will hurt you. I will use the materials you give me to wreck this place or to harm myself. And in that situation, our counsel has been, through legal and whatnot, to, not provide those opportunities to harm himself or to do harm to somebody when he's made that solid commitment. So that's one of our toughest challenges still, is how do we get that educational offering into the hands of that juvenile who clearly is a threat. Like I said, that doesn't happen very often, and it doesn't happen for a long duration. But those are some of the things in a nutshell, and I hope, Haley, I've covered kind of what you're looking for there, but that concludes kind of what I was covering.
Yeah, thank you so much, Kevin. I think that's incredibly helpful. And I appreciate your candor in thinking through some of your struggles. Our next polling question really deals with what Kevin's talked about, some of the issues that he's dealing with, these ideas of having individualized discipline plans for students' needs that include identified special education or behavioral needs, and some of those struggles that you might also be having. We'll take a few moments. You can click right on the screen, and then Kevin will have a chance to respond to maybe what some folks are struggling with in their spaces. All right, Kevin, what are your thoughts taking a look at? Looks like most people say that this is their policy, but implementation is a challenge.
Yeah, that is
encouraging words. Yeah.
Yeah, yeah, that's very telling because we find the same thing. It's a policy is fantastic in its written form, and we can fully be behind it. And then the challenge is to consistently and effectively on the floor find ways that are communicated clearly, that are enforceable, and that if fail, you can find where the gap was and fill it. And that's such a difficulty with the implementation of policy. It's interesting to note that another agency has control over 23%, and it doesn't say whether that other agency's decisions are supported or not or agreed with or not, but that can certainly be a challenge as well. We have had to do a lot of touch-ups on certain policies because we felt that they provided too much wiggle room to where we can feel really good about ourselves but really aren't making that effective of a change. And we wanted to tighten that up and really put ourselves on the hook for performance. And others where the bar was set so high that the policy made us look really good, but in actuality we could never meet it, and so we had to more realistically write those, and I know that's one approach to that policy issue.
Thank you, Kevin. 2 points I'd like to quickly make on this one. First, for those of you whose concern lies in the interagency cooperation, we come back to Kristen's point about the importance and actually the requirements of having these interagency agreements. This is a place in which you want to make sure that you have a really detailed agreement and that you reach common ground and everyone has bought into what your plan is going to be, so that you aren't then on the ground in the moment confronted with conflict over how to best resolve a volatile situation. The other point I'd like to make is that we at CEEAS has a short set of best practices, a document that we derived looking at some of the information that came out from Contra Costa, what we've seen when we've been out at sites, when we've seen great practices like what's happening in Lewiston. And those are going to be available in the resource documents that you're going to receive. It provides our recommendations for steps that you can take to begin to redesign your segregation and isolation program with an eye on making sure that kids are getting the maximum educational experience possible. So we've got 15 minutes left. I want to be thoughtful of our time, probably even less than 15 now, and move into our discussion of the federal civil rights protections that go beyond these special education issues. Saba, I'm going to turn it over to you so we can walk quickly through these, and then we'll have some polling questions at the end for folks to discuss.
Thank you. Once again, my name is Saba Biretta. I work at the Office for Civil Rights at the Department of Education, and I'll try to go as quickly as possible over some of the highlights from the Civil Rights Letter, which was also part of the Disciplinary Guidance Correctional Education Package released last year. We wrote this letter jointly with the Department of Justice, and the reason we did that is because both of our agencies, as I'm sure many of you are well aware, are responsible for enforcing civil rights in our nation's schools. And so just quickly, so you have an understanding of how we view that work and how the laws that we enforce work, OCR and DOJ both enforce Title VI of the Civil Rights Act, Title IX of the Education Amendments of 1972, Title VI, of course, dealing with race and national origin and color, Title IX focusing on gender. We also both enforce Section 504 of the Rehabilitation Act and Title II of the Americans with Disabilities Act. DOJ solely enforces Title IV of the Civil Rights Act and the Equal Education Opportunities Act, which I will talk about a little bit more. And as Kristen noted, our purpose in writing this letter was to also really emphasize that the civil rights protections afforded to students in public schools across the nation also extend to students who are attending school and receive educational services in juvenile justice residential facilities. So with this first slide, just one key point from the letter, we have noticed there's, of course, a growing number of English language students in our nation's schools, and that population is also growing in the juvenile justice population. And so one key point here is that Title VI and EEOA actually provide protections for those students. And really the idea that I'd like you to take away here is that we want to make sure that all EL students are receiving a program or receiving the supports they need to meaningfully access your educational program. And there's a whole series of guidance that we have and resources that we have available to help you with this effort. But the key takeaway there is that students really do have to have an educationally sound and effective language program to help them access the curriculum, and they also need to have the staff and resources available to help them be successful in that program. It does not mean that you have to have a particular immersion program or a particular bilingual ed program. There are legal standards, which I can talk to you more specifically about if you have questions. There are legal standards which we look for when we're making sure that the program program that you're offering is educationally sound. This is just a slide of the EL guidance that we released in January, just last month. It reviews all of the legal standards that I just mentioned and really addresses some common civil rights issues that come up when providing services to EL students. For instance, identification, how you develop a program, how you staff your program, importantly, how to make sure EL students are receiving access to even non-academic services like extracurricular activities, and how to guard against unnecessary segregation. So if you're interested, please look on the OCR website, which I can send out later. We have, like I said, a whole resource page with this guidance and several toolkits from our Office of English Language Acquisition. So if this is an area of need for you, we really do have quite a few resources available. The next slide, I know sometimes this gets a little confusing in terms of the intersection of the IDEA, as Kristen was talking about, and then the civil rights law that we enforce, the civil rights laws we enforce, which include Section 504 and Title II. But importantly, Section 504 also requires that students who have a qualifying disability or receive FAPE. That means they need to receive aids and services designed to make sure that they meet their individual education needs. But as many of you know, by meeting a student's needs through the IDEA, you often can actually fulfill the requirements of Section 504. Section 504 also has similar least restrictive environment protections for students. So to the extent possible, students should be educated with other students who are non-disabled, and students should have access to activities, non-academic activities like rec time with their non-disabled peers. Next slide. So this obviously is a big area, student discipline. We released guidance last January on the administration of discipline with regard to race, national origin, and color. This is obviously a big issue across the nation in our nation's schools, and as I said, it remains an issue also for students in juvenile justice placement. So the discriminatory application of discipline is, of course, an issue that we would look at in terms of our investigations. But one key piece of the letter, which Kristen alluded to, which is a position that the United States took in the Contra Costa case, is that the ADA's Title II requires facilities to implement reasonable modifications so that students with disabilities are not placed in solitary confinement or other restrictive programs because of their disability-related behaviors. And that's really the key point, that the ADA's Title II protects facilities to take reasonable modifications to make sure that students aren't being punished with solitary as a result of their disability-related behaviors. Just in terms of the discipline piece, I'll just add, because I know this is a big area of questions for a lot of people. Please look at ed.gov/school discipline, which is our school discipline resource page. It tells you a lot about our work in this area, because it's really important that you understand as you're administering your educational programs that those protections around school discipline really apply throughout your disciplinary program and your school-based program, that means referrals, detentions, suspensions, all of those need to be administered in a non-discriminatory manner.
All right, thank you so much, Saba. So we're actually going to close out with our last polling question and kind of skip the next ones. But I think this is a really important one, is for folks to think about, we've talked all about what the expectations are, what the requirements are, but are there systems in place to track records of student discipline, harassment, and violence that you're analyzing and responding to patterns that are based on things like sex or national origin or color or race? Because unless you know what your data is, it's actually very hard to change your practices. You can choose as many that apply right there on your screen, and we'll get a chance to talk through those quickly. Okay. So again, it looks like for a lot of folks, this is something that you're putting energy and effort into, but implementation is difficult. This is, again, I would say, one of those places to look back and think about your interagency agreements. If the struggle is simply collecting the data, how do we know even what's happening day to day at sites? That's something that can be built into your interagency agreements, is thinking about that data collection. If the struggle is in analyzing the data and making decisions based around that, that's where you might want some additional support from folks over at the DOE or DOJ in helping you think through, you know, we found these patterns, what do we do next? Saba and Kristen, anything quick to add?
Just adding yes to the importance of record keeping, especially for discipline. That's a key area that we look for in our OCR investigations. And then with regard to gender-based harassment, I'm sure many of you know this, Title IX does have a requirement around having a Title IX coordinator for those facilities or school districts that are receiving federal funds. And the Title IX coordinator can play the role of really paying attention to issues of gender-based harassment and making sure that those are being resolved.
All right. So what I'm going to do is we had a few more polling questions, but I want to be respectful of the time of everyone who's on the line here. And I want to actually move us through to the end of our PowerPoint presentation, where we're going to give you some information about seeking technical assistance, who you can reach out to for support. So if you, in having these conversations, would like some individualized assistance, or you have questions that you need specific answers to about an individual student, an individual site, a particularized problem, you can reach out to any of the Office for Civil Rights regional offices, and there'll be a link there. That's something that you can look up online. You can reach out and contact them. There's an 800 number for their customer service team, and 2 email addresses, Office for Civil Rights, which is part of the Department of Education, and the Educational Opportunities section, which is the Department of Justice. And they're both there very much to offer you support. We all understand that this is very, very difficult work, and that there are challenges and that it is complicated. And the folks we've got on the phone today, and anyone who's going to answer the phone on these places here, they want to hear from you. They want to answer your questions. They want to help you. They want to make sure that you and your kids have the resources that you need to provide them the kind of education that I know that you want to deliver for them. So please, this information will be, again, in the PowerPoint that you'll receive when it comes around. I hope that you will feel comfortable reaching out to any of those folks. In addition, other questions, support that we can give you either from CEEAS on implementation and best practices, or specific questions that you've got for Frank or for Kevin about what they're doing, how they've done it, what they're struggling with, we're all available to you. You see my name on there, Frank and Kevin. We've also got Chrissy Sampson-Kelly, who's our Director of Practitioner Support at CEEAS, who can help you, who's been in a lot of sites and helped folks really move the ball on some of these issues. We're all available to you at any time. So please reach out to us, email us, bug us. We're happy to hear from you. And I want to actually, sorry, we've got one quick question that came up from a few people about Pell Grants I want to make sure that I answer, is whether or not kids who are in privately contracted facilities would be eligible. And Kristen's answer is that whether or not the kid is in a privately versus publicly run facility is not the issue. It's whether they're in a state or federal penal institution. So if the privately contracted facility is a juvenile justice state facility, yes, kids are eligible for Pell Grants. The only other issue is whether it's a state or federal penal institution. If it's a juvenile justice facility, even if you've contracted it out to a nonprofit or private provider, the kids would be eligible for Pell Grants. Again, more detailed questions can head over to Kristen or can head over to folks in her office, and they can help you walk through whatever the detailed issue is that you're having. I'm going to hand it back over to Brendan. I'm only 1 minute over time, so thank you all so much for spending your time with us this afternoon.
Well, thank you, Haley, and all of our panelists here today. I just want to say a special thank you for all of you for participating and remind you all that there'll be a copy of today's presentation available. We'll be emailing you the presentation, any of the links that were talked about during today's presentation, video recording, everything will be sent in a follow-up email to you sometime next week. Usually goes out within about 5 to 7 days following the presentation. When you leave here today, be sure to take our 5-question survey at the end of the webinar. It really helps us design and develop these webinars for future presentations, so your feedback is greatly appreciated. CJCA will be announcing any other future webinars. You can learn more about that by following CJCA on your favorite social networks, or you can also go over to the CJCA blog for more information. So on behalf of myself, CJCA, and all of our panelists today, thank you again for attending, and I hope you have a great afternoon. Thanks. Bye-bye.